Members, welcome to the meeting of the AJRS panel. We have formed a quorum. I now call the meeting to order. Information issued since the last meeting, CB bracket 4. And that is a letter from Mr. Dennis KWOK requesting that we should invite organizations to give views on the issue of future development legal aid in Hong Kong. And then we have another paper, CB4670-1213 bracket 01, a letter from Mr. Leung and Mr. Wong Yuk-man, dated 22nd of May 2013, requesting to discuss the issue of a handling of cases by court masters. This is in Chinese version only. As for items to be discussed at the next meeting, please refer to CB4679-1213 bracket 02 for the list of outstanding items. For the next meeting, we are going to held on the 25th of June at 4:30 p.m. Two items have been proposed by the administration. First, implementing the recommendations made by the Law Reform Commission. The Law Reform Commission has provided a written report to the panel on the progress of the administration's implementation of LRC's recommendations. Second is item, establishment of an independent legal aid authority. On the 30th of April 2013, the Legal Aid Services Council submitted to the CE its recommendations on the feasibility and desirability of the establishment of an independent legal aid authority in Hong Kong. While the LASC agreed that there's no immediate need to establish an independent legal aid authority, it has recommended a host of measures to enhance its function, to oversee the delivery of quality legal aid services, to strengthen the governance and operational transparency of the legal aid department. The administration is going to brief us on the progress so that those two items will be discussed on the 25th of June. In respect of the establishment of an independent legal aid authority, Mr. Dennis KWOK has written in to request that we invite organizations to give views on the issue of future development of legal aid in Hong Kong. So, members, do you agree that we should invite organizations to give views in our June meeting in respect of the item on establishment of an independent legal aid authority? Any comments? Well, I take it that members do not object. Actually, this is a subject that we have discussed many times, and we are going to invite the relevant organizations to give their views here. And at the last meeting, we received a letter from Mr. Leung Kwok-hung and Mr. Yuk-man concerning handling of cases by court masters. That's paper CB4670-1213 bracket 01. So do we agree that this will be put on the list of outstanding items for discussion? Some members who were with us last time, and there was a discussion on this, Mr. Leung Kwok-hung has amended his letter. It was rather abstract last time, and now it's been beefed up with more substantive contents. I believe members have read Mr. Leung Kwok-hung's letter. Actually, Mr. Leung Kwok-hung has also submitted some documents. I understand that those documents were provided by the relevant individuals to the Complaints Division. We have consulted our legal advisor. In that bundle of documents, some correspondence is included, and in some of them, names of judges are mentioned, and we may need to process those documents. So maybe I should invite the legal advisor to say something, because Mr. Leung Kwok-hung has distributed the same documents to other members for ease of reference. So, legal advisor, with regard to the letter submitted by Mr. Leung Kwok-hung and Mr. Yuk-man's letter, I think the panel should consider a few things. Normally, a panel is not supposed to deal with individual cases. According to Rules of Procedure, Rule 77(3), panel should discuss policy issues. But in a panel meeting, in the discussion of policies, members may refer to individual cases to elaborate on their stance with regard to certain policies. So that may be done if that members deem necessary. But in principle, a panel will not handle the cases. It should only discuss policies. So the panel may wish to decide whether this issue should be discussed in the panel, and if so, what would be the policies involved. And also, Madam Chair, I would like to mention that in our list of outstanding items for discussion by the panel, that is CP 4679 1213(01), we have one relevant item, and that is number 6, judicial manpower situation at various levels of court and long court waiting times. So maybe the issues raised by the two members can be taken up as a form of policy discussion with regard to item 6 on the list. So panel members may consider whether it would be appropriate to distribute the documents of that particular complaint case to members. If the documents are so distributed, the public will have access to the same set of documents. So maybe the panel should consider how to proceed with prudence. And if there are some confidential information, maybe the documents have to be processed before distribution to members. And also, before distribution of the documents to a third party, consent from the relevant parties might be required. So apart from the complainant and in respect of correspondence, the correspondent, the other party to the correspondence, might need to give his consent before the document can be given to third parties. And if there are personal data, such as references to telephone number, addresses, they should be covered or deleted before distribution. Otherwise, such personal data will be in the public domain. And if the contents would be regarded as defamatory, the usual practice for the Secretariat will be to break out the relevant parts or to delete them before the distribution to members. Okay, so we have an input from the legal advisor that we started a little bit later than scheduled. So I would give sufficient time to Mr. Leung Kwok-hung and Mr. Yuk-man so that they can say something about the topic, about the subject for members' reference. Who will start? Mr. Leung Kwok-hung. Madam Chair, thank you. At the last meeting, I submitted the letter, but without the other information attached this time. So members thought they didn't understand what I was driving at. So it was thought that it should be put on the list of outstanding issues. So I have made available more information. according to the legal advisor, we have our own principles to uphold. The legal advisor's advice is for the reference only. We can decide whether to act on in accordance with his advice or not. In relation to this case, if someone in the judiciary does something unlawful, and if it impinges upon the institutional fairness of the judiciary, then it's a policy issue. The judiciary says it's not supposed to have happened, but it has happened. The judiciary has a duty to answer our question, and that is whether there are court masters dealing with cases on behalf of Court of Appeal judges. If so, is this lawful? Is this in accordance with their policies? I believe this issue should be taken up by the AJLS panel. I have written to S4J, and the S4J says this is a matter for the judiciary. We represent public opinion, and we monitor the work of the executive and the judiciary if they act outside the law or unconstitutionally. If you look at the annex documents, you see that this is a policy matter. Why is it that court masters are doing this against the law? They are dealing with cases that they are not supposed to handle. Are we talking about isolated cases? If not, shouldn't we put a stop to it? Do we need to provide more manpower to the judiciary to stop this? Should there be a better mechanism within the judiciary to deal with malpractices or unlawful or unconstitutional behavior of people working in the judiciary because they enjoy autonomy? I have to remind members that the only venue to deal with such a case is the AJLS panel of this council. If there's another one, I'll be more than happy to be reminded about that. Those are the channels. If you say we don't handle individual cases, remember Ms. L.C. Leung? She said we had the basic law. There will be no change for 50 years. We invited her to come to air her views. I am involved in many court cases. For one, I have been sentenced to 2 months imprisonment, and I'm now appealing. And these court masters might be the one who increase my sentence in due course. I'm a taxi. If you get some information to me, I would put up a fight for the public. If you think this is not a policy issue, it doesn't matter. Well, we have a complaints division, so please go to the complaints division to help. We have so many lawyers here. Okay, I'm going to give the floor to you in a moment. This is the second time Mr. Leung Kwok-hung and Mr. Wong Yuk-man have raised this, so I believe it's only appropriate to give them some time to say what they think, and actually they have distributed the documents to other members. For the second item, we we make preparation for 10 odd deputations to come, but actually 5 have signed up, so we have more time than needed for the second item. So if members do not object, I will extend our discussion by 10 minutes. The members may wish to offer their comments, and then we would decide how we should handle this. Next, I will allow Mr. Wong Yuk-man to have a brief introduction of this. Let's say 2 to 3 minutes. 3 minutes, Mr. Wong. I'll allow you to speak as far as possible because our time for today's meeting is somewhat more than adequate. This is a clear-cut case. You know what the complaining is complaining about.
And we met with this complainant at the complaints division. We have taken a look at the information on a preliminary basis, and that is within the case. And the case reflects the policy behind. The judiciary claims that it can't make mistakes. Well, I've read some books on the rule of law, and they cast doubts on the judiciary. Now, in common law jurisdictions, there are problems, and in continental law systems, there are also problems. Say in Taiwan, in China. In Taiwan, recently, there have been discussions on the problems in the judiciary. But Hong Kong has been practicing common law successfully, and because of this, we have to make sure that the judiciary discharges its duties in a just manner. And because this is the bottom line of our judiciary system, if we don't conduct investigations thoroughly, how can we stamp out loopholes in the system? Well, let's cast aside the individual case. Well, the SC here, can you tell me whether you can guarantee that there are no flaws in the system? There are indeed cases of cases being handled illegally. Now, for these cases, if the complainants appeal, what is going to happen? Now, say if I want to make an appeal, then I have to get a transcript at a cost of, say, $300,000. So isn't that show that there is a problem with the system? I have to pay such a high cost before I can make an appeal for the transcript. And that transcript includes my submissions in the court. Now, if I'm poor, I don't have money, I have to prepare myself to be imprisoned. Also, how are you going to hold someone responsible if there is anything illegal happening in the system? We've got different layers of the courts. Now, if there is corruption or illegal handling of the cases, what are the remedial measures in place? Now, if you want to take it to the street to protest, then you will be arrested. So I think this issue is worth discussions here, unless you tell me that information in the document is mistaken. Okay, let's listen to the views of the other members. Mr. Ronnie Tong. Sorry, I was absent in the last several meetings because of some other engagements. This is the first time that I read through the document. And this is a complaint against the misjudgment or the mishandling of a court judge. And this is really a complaint case. Now, I met with the Chief Secretary for Administration. I protested to her that Hong Kong has separation of powers. And then the executive arm shouldn't interfere with the legislature's operations, and similarly, legislature shouldn't interfere with the judiciary. Now, if we want to complain against a judge, then that has to be done within the judiciary system. And the person to handle this case maybe is the Chief Justice himself. Now, if the LegCo, using our own capacity or a name, to deals with a case being handled by a judge and saying that he has mishandled the case, I think that infringes on the separation of powers. While I agree with Mr. Raymond Wong on some of the points he made, but within the existing system, I think the case should be handled by the Complaints Division colleagues who should deal or reflect the case to the Judiciary Complaint Channel. Dr. N. Zhang, I was listening to Mr. Ronnie Tong's remarks, and then I thought, if LegCo doesn't deal with complaints against the judiciary, who is going to handle it? Is it the judiciary who is going to handle it itself, or is it the executive arm? I want to add this point. Mr. Ronnie Tong talked about the complaints division. Actually, I participated in the handling the complaint. In the initial stage, we sought a reply from the judiciary, and then we heard the case. Now, we'll deal with this later on because I want to listen to some other members' views first. Mr. Dennis KWOK, Madam Chair, I've spoken on this in the last meeting. If someone, well, I think it's worth discussing the discussion of the how the judiciary handles its own complaints, whether there are any problems. I think this is a matter that falls within the ambit of this panel. Now, as for the individual behavior or ruling of an individual judge, then that should be handled within the existing mechanism of complaints in the judiciary. Now, if there is any problem with that mechanism, then that can be put forward to this panel for discussion or study. Now, actually, after the last meeting, Madam Chair and you yourself and I have discussed that that can be put as an agenda item of this panel, and then also can be merged together with the discussion on the resources of the judiciary. Mr. Tan Ka-pyu, I'm not a legal expert. I am a frontline district councillor. I've encountered many cases of sort of misruling by the judges. We didn't know how to handle them. We just put forward the complaints over to the judiciary's complaint mechanism. Now, whether this mechanism works or not, I think we should discuss that as an agenda item of this panel. And this is something that we should discuss, how an ordinary member of the citizen can face or have complaints about the judiciary. Mr. Albert Ho, next. Madam Chair, I agree with Mr. Dennis KWOK. If there are problems with the judiciary system, I think the panel is duty bound to study it. Now, as for specific complaints or specific rulings or individual personnel's behavior or acts, I think that should be resolved within their own system. I think there is a separation of power. I think as a representative of the public, I think we can help them lodge a complaint. I have actually written a complaint on behalf of the complainant, and then I handed it over to the judge of the Court of Appeal and tried to get a reasonable reply from the judiciary. I think that can be achieved. I think we can listen to the complaints, but then we shouldn't be interfering with the complaint procedure. Well, thank you, members. I've heard your views. I have this suggestion for members' consideration. After the last meeting, I have talked to various members. Our suggestion is this. Now, on the complaint of an individual case, as what one member said, we should hand it over to the complaints division of LegCo, and they can handle it as, say, a case management approach. Now, if members are interested in following up on this case, perhaps you can join us in or participate in the work of the complaints division. Now, as for the terms of reference of this panel, in fact, in the appointment of Judiciary Personnel Committee, we also discussed that, and we wanted to follow up on this. Members of the public may have complaints against judiciary personnel. They're not familiar with how to go about doing it. Perhaps we can ask the judiciary to come to this panel to explain in detail how that works. And perhaps they can follow up further on how they can deal better with the public's complaints. Well, in fact, many LegCo members have received complaints from members of the public about certain court cases, and we don't know how to follow up. So I think the mechanism can be discussed here. We have some specific suggestions too, and I hope that you would agree. In the next meeting next month, we've got sufficient agenda item number. And in July, we hope to discuss the resources of the judiciary as an agenda item. I think the resources are scarce in the judiciary, and we hope to help the judiciary in getting more resources to improve the services. Perhaps in that meeting, we can add an extra agenda item, and that is the judiciary's complaint mechanism. We can focus on the mechanism.
Two members have raised their hands, but first of all, please let me talk about how we should handle this. We have exceeded the 10-minute allowed. For July meeting, it will be held on the 23rd of July. If we want to take up these two items, well, which are very relevant to our duty, so please make a point to attend. That's the 23rd of July. We need a substantial quorum. There's an alternative date. That is the 11th of July, a Thursday, at 4:30. Or we can have a meeting before our council meeting to ensure a bigger turnout. Two more members would like to speak. I'll give you 2 minutes each, and we have to wrap up. And perhaps you can also respond to my proposal on the administrative arrangement. Mr. Martin Liu. Essentially, I agree with you, Madam Chair, and I also agree with Mr. Dennis KWOK. There are a few points here that I want to make. After that meeting, if we come to some conclusion, what are we going to do with it? That's the first question. According to the basic law, we can monitor the government, and that means the executive and maybe also the judiciary, maybe the legal advisor can advise on that. Second, in respect of our power to monitor the judiciary in respect of financial matters. That's within our power. But what about our jurisdiction over the judiciary? Under our constitutional system, under the basic law, would there be any conflict in respect of the idea of separation of powers? Ms. Emily Lau. Well, I don't have strong views about your proposal. I hope more people would attend our July meeting. There's another item that I want to have some discussion sooner. That's item 11, and that is about the applicability of the ordinances of Hong Kong SAR to the offices set up by the CPG in Hong Kong SAR. Recently, some cases involve the liaison office. Well, this matter was last raised in 2011. Maybe we should get some more information so that we can revive the discussion. We don't want to give people the impression that some organizations are above the law. Mr. Leung Kwok-hung. There are two people, Aoyong Kwai-yu, court master, and another person have given us two versions of the facts. Whether we use our complaint handling mechanism or theirs, we need to sort this out. Is it appropriate to get someone from the judiciary to answer our questions? First of all, it's difficult to identify the right person. We are not able to find the right person. If this is not a common practice to have court masters handling cases on behalf of high court judges, then if this is a practice, we'll have to ask questions, just like the substandard buildings in Sichuan. How are we going to deal with such cases? It would be very laughable if having raised this, we are not able to handle it. And now we have been presented with the facts. There are three victims: Mr. Wong Yuk-man, I myself, and the complainant, who may be subject to reprisal by the courts. You may say that after listening to the complainant, we can just leave it as it is. But this is a systemic problem. How can it be any other problem? In this solemn organization, that is the judiciary, two people told us two different versions. And if those things are not sorted out, they may lead to the corruption. Legal advisor? Yes, I can provide a brief response. Since the judiciary is independent, if the Legislative Council wants to discuss issues about the judiciary, we have to proceed with caution. But actually in the past, we did discuss matters related to the judiciary, such as the adjustment of remuneration of judicial officers. And as Madam Chair has pointed out, we also discussed resources for the judiciary, and some time ago, the relocation of Court of Final Appeal. So there may be topics that we discussed that are related to the judiciary. But since the judiciary is independent, we have to proceed with a high degree of care. Mr. Leung Kwok-hung. Mr. Leung Kwok-hung, if you want this panel to handle this, you must let me speak. With regard to my proposal, that is to say, we can look at the mechanism. We can have a discussion on the complaint handling mechanism. We did discuss a similar mechanism of the ombudsman. Maybe after this, we can refer the case back to the judiciary for its handling, because the public may not understand that they have a separate mechanism, and therefore they come to us for their complaints. So members, what do you think? If we advance the meeting from the 23rd to the 11th of July, 4:30, on that said Thursday, it's a Thursday, what do you say? I repeat, it's 4:30 p.m. on the 11th of July. Because by the 23rd of July, we'll no longer have any more council meetings. Again, please. 11th of July, a Thursday at 4:30 p.m. We want to do this before we have convened all our council meetings. On that day, there will be a council meeting. How can we convene a panel meeting while there's a council meeting going on? You may have to cancel it after all. Okay. What about the 23rd of July? We can resort to we can fall back to the original date. Can we schedule the meeting on the 11th? And if we are going to have a council meeting at the same time, we will then try to find another arrangement. Let's hear what members want. The original date is the 23rd of July. We've informed members of the final decision if more members can attend that meeting. We now move on to the third item. Again, please. In the July meeting, we'll discuss resources for the judiciary, and we're also going to discuss another item, and that is the complaint handling mechanism of the judiciary. We'll discuss the mechanism, and we'll also ask the judiciary to give us a paper. I object. Let me say why I object, and I'll be done. I would say this is not a question about resources. Second, we have the duty to clarify what we already know. We should seek views from the judiciary. If they can send someone to our meeting, they should tell us their policy. Well, we're talking about two different items. We're not trying to lump the item on the resources with this one. There will be one item. The second item is on the complaint handling mechanism of the judiciary. I think we should ask the judiciary to send someone to come to explain to us whether, as a matter of system, they have asked court masters to hear cases on behalf of high court judges. Yes or no? That is not about the complaint handling mechanism. Well, Mr. Leung, Kwok-hung, we have heard you, but I have to respect other members' views. So that's the end of this particular item. We are going to arrange a meeting with this item on the agenda in July. Well, now we return to item 3. Right of appeal issues of children born in Hong Kong to mainland parents, both of whom are not Hong Kong permanent residents. It's CB 4670/1213/02. That's the Law Society's submission. And the 695/1213/03, a paper from the administrations regarding right of appeal issues of children born in Hong Kong to mainland parents, both of whom are not permanent residents. The other is a CP4 679/1213/04, and that is a paper, a background information paper prepared by the Secretary on the interpretation on the procedure for seeking an interpretation of basic law. And then we also have a submission from the Bar Association as a declaration concerning the foreign domestic helpers case of right of abode. Let me welcome our guests. Let me invite Mr. Rimsky-Yuen, Secretary for Justice, and Mr. Leung KWOK, Secretary for Security, to say something about the discussion paper entitled Right of Abode Issues of Children Born in Hong Kong to Mainland Parents, both of whom are not Hong Kong permanent residents. Over to you, S4J. We are now on the third item of the agenda. The DOJ has submitted a paper to the panel which sets out the position of the DOJ. I'm not going to repeat the contents. Let me just highlight a few points. Since 2001, when the CFA handed down a judgment on the Zhong Fengyun case, the number of so-called Type 2 children have increased from 610 to 35,736 in 2011. And this has put a lot of pressure on our policies regarding to population, education, healthcare, and so on. The administrative measures adopted by the government have proved to be effective, but they are not long-term solutions. Therefore, we need to adopt various means, including legal means, to come up with a long-term solution. In the foreign domestic case, foreign domestic helpers right of abode case, we propose that the CFA should seek the MPCSC's interpretation, because in that case, the Court of Final Appeal might have to rely on Basic Law 158(3) to ask the MPCSC to clarify the relevant interpretation back in 1999. If the CFA fought fit, the MPCSC's interpretation might also help us in resolving legal issues regarding these so-called Type 2 children. As the Court of Final Appeal was of the view that they could rely on other grounds to rule in favor of the administration. Therefore, there was no need to seek the NPSC to elaborate on the 1999 interpretation or the effect of the 1994 preparatory committee's views. We respect the Court of Final Appeal's position. Type 2 children's right of abode is a complex issue. The existing administrative measures have been able to put a stop to mainland pregnant women giving birth in Hong Kong. We'll continue to adopt these measures so as to minimize the impact on the community by these mainland pregnant women. And the Secretary for Security would give you a brief introduction on the relevant administrative measures. The DOJ, together with the relevant departments such as the Immigration Department, would continue to assess the feasibility of various measures. The main consideration in doing this will include, first, we would, as far as possible, rely on legal channels within the SAR, Hong Kong SAR. Second, we have considered whether there are good justifications of adopting certain legal procedures, legal means, and whether by resorting to those legal means and channels there will be a negative impact on the community. And then fourthly, we'll also assess the actual problems by implementing certain procedures. So we are going to weigh the pros and cons of various options and the implication on the rule of law. We'll be mindful about the overall public interest in doing any of this.
Mr. Leung KWOK next, Secretary for Security. Madam Chair, members, I would like to share the administrative measures on mainland pregnant women. From 1st of February 2004, the government has implemented the obstetric services, special arrangements to ensure that local women can enjoy the services as a priority. And we will try to stop the gate crushing of mainland pregnant women in ANED. Non-local mainland pregnant women must make an appointment first if they want to give birth to local hospitals, and they have to be given a certificate by local hospitals. In 2012, the government has implemented a quota system for mainland pregnant women, and then there is a zero quota for mainland pregnant women. In the policy address this year, the CEs decided to maintain the zero quota policy as a long-term policy. And mainland pregnant women whose husbands are local women, or those pregnant women who hold a one-way permit to Hong Kong, well, mainland pregnant women can, under special arrangements, make bookings for delivery in private hospitals in 2013. Now, to tie in with the above arrangements, the Department of Health and also the Immigration Department has implemented immigration controls. Mainland pregnant women who have been pregnant for 28 weeks and who can't present a booking certificate, and maybe her entry purpose or intentions are dubious, the immigration officials can refuse entry to these women and may repatriate them immediately. At the end of 2011, the Immigration Department has beefed up its immigration control measures. The number of mainland pregnant women coming to Hong Kong without booking, the number has dropped drastically. From the fourth quarter of 2011, there is an average of 160 cases. Now, in the first 4 months of this year, the number has dropped to 18 per month on average. Now, also, the administration has also established a liaison mechanism with the Guangdong authorities to enhance our intelligence exchange to stem out mainland pregnant women gate crashing ANED of hospitals. And we have also cracked down on the intermediaries. The enforcement departments have also strengthened their surveillance on mainland pregnant women and cracked down on cases of mainland pregnant women coming to Hong Kong, including having forced marriages with Hong Kong husbands. Last year, the Immigration Department has set up a special duty team to make analysis on dubious cases, and 5 women to date, and 15 local people who are suspected of helping these women to come to Hong Kong, including the intermediaries and the cross-border drivers. They have been prosecuted, and the highest sentence is 18 months imprisonment. Now, these measures have achieved some results, but then the Immigration Department is still under heavy pressure as far as enforcement is concerned. Now, there has been an increasing number of travelers to Hong Kong from the mainland. With our limited resources, we have to maintain an effective immigration measures. We still have to crack down on mainland pregnant women. And then we have to deal with some 30,000 to 40,000 mainland pregnant women cases. We have to question them, and if we found that they are dubious cases, we may refuse their entry and repatriate them immediately. Last year alone, over 42,000 mainland pregnant women have been repatriated and refused entry to Hong Kong. Now, we need a lot of people to do that work. Now, a lot of mainland pregnant women have chosen to come into Hong Kong during peak hours, and they use all sorts of tactics to cover up their pregnancy, and that increases the difficulty of immigration officials in cracking down on them. And some of them have waited till the last minute to come to Hong Kong, and that poses a lot of pressure on the immigration officials, and they are also putting their health at risk or safety at risk. Now, the immigration officials have been maintaining a good immigration control. But giving birth to Hong Kong is still an attraction to mainland pregnant women, and these women will still use all sorts of tactics to come to Hong Kong to give birth. So under the leadership of the Secretary for Justice, the administration will proactively study various measures to solve the problem. Thank you, Mr. Lai. Mr. P.Y. Lau from the Hong Kong Bar Association. Madam Chair, members, and government officials, I have to say sorry first because I'm not feeling well, so I might have to leave a little bit early today. But I hope that through the meeting, I would like to share the Bar Association's views and statement after the ruling of the foreign domestic helpers case. The paper is in front of everyone. Now, in our statement, we reiterate that the Bar Association has submitted its views to the AJSL panel. Now, if the SARG wants to seek interpretation of the basic law from MPC-SC, there are points that the administration should note. There are two papers. Mainland pregnant women giving birth in Hong Kong. The SARG is still thinking of drawing up legal measures to resolve the problem. The SARG is thinking of legal measures which may include the CE seeking interpretation of the basic law from the MPC-SC. Now, on this, the Bar Association calls on the administration to tread carefully. Now, in view of the Chong Fong Yun case, the CFA has unanimously, among the 5 judges, handed down a ruling on the Basic Law Article 2421, and also in the ruling on the foreign domestic helpers case. The administration has also suggested to seek an interpretation of the basic law. Now, on page 79 of the ruling, it says that the interpretation of Article 2421, the word born, what does that mean? If the SARG seeks interpretation of the basic law from the MPC-SC, well, actually, for these 2 cases, the CFA has made clear ruling. And if the government is going to seek interpretation from MPC-SC, that would overturn the ruling of the CFA, and that is going to undermine heavily the rule of law in Hong Kong. We hope that the government can consider carefully whether to do that. Now, I would like to ask Mr. Charles Chow from the Law Society of Hong Kong to speak. Madam Chair, members, good afternoon. The Law Society's stance as this has been very clear all along. According to Article 2421, Chinese citizens born in Hong Kong before or after the establishment of the Hong Kong SAR has permanent resident status. Now, in the Chong Fong Yun case in 2001, the 5 judges of the CFA unanimously held that Children born in Hong Kong to mainland parents, neither of whom were Hong Kong permanent residents, were entitled to permanent residency of Hong Kong. The Hong Kong government did not challenge the CFA's judgment at that time, and it did not seek an interpretation of the basic law from the MPCSC. Our society's position has always been very clear. We think that too many interpretations of the basic law by the MPCSC can undermine substantially the independence of the judiciary and the rule of law. And these two are recognized as core values of Hong Kong. The Law Society also notes that the administration has adopted various administrative measures on this issue. And on the surface, they have proved to be rather useful. And actually, from statistics, we can tell that the number of babies born from such mainland pregnant women have dropped. So we think that the administrative measures are necessary. Lastly, the Law Society, as in the past, considers that issues in relation to the Chong Feng Yu case should be resolved in accordance with the established legal principles. Any further attempt on the part of the administration to seek an interpretation from MPCSC to resolve the mainland pregnant women issues will undermine the independence of the judiciary and the rule of law. We don't agree that the administration should seek interpretation of the basic law to resolve the mainland pregnant women issue.
It's now the time for members to raise questions. We have Mr. Dennis KWOK, Mr. Michael Tin, Mr. Albert Ho, Mr. Wong Yuk-man, Ms. Emily Lau, Mr. Tam Yu Chung. So, Mr. Dennis KWOK, you go first.
Madam Chair, I want to refer to paragraph 13. Other options. Would that include seeking interpretation? Would the administration take the initiative to seek interpretation under other options? Regarding seeking interpretation, the SAR government is all along aware that it's going to be controversial if we do this. So since July last year, we have been stressing that we would try as far as possible to stay within our local legal system to handle this. And why do we want the Court of Final Appeal to invoke Article 158(3) in the foreign domestic helpers case? Because that's also a procedure allowed within our legal system. As I've said, we'll continue to study and look into the possibilities of other options. We have set out our major considerations. And the first point, as I have stressed, and that is we're going to pay attention to our legal system's integrity. So in other words, under other options, you are not going to cover seeking interpretation from the MPCSC. As we said in the past, we understand whether or not to seek interpretation is sensitive, is controversial, and therefore we have set out the considerations that we are going to take into account. I think this is a position that members can understand as to what we are going to do in the future. We are going to assess our local circumstances, and as the Law Society representative has said, there are views from certain quarters in the community that our administrative measures have worked well. Of course, we are going to consider such public opinion. And on the 25th of March, the CFA handed down its judgment with regard to the right of abode of foreign domestic helpers. and you would know whether we have done anything as suggested by Mr. Dennis KWOK along the line of options. Let me say something more about paragraph 13. Other options. What other options are being considered?
I hope we'll not be discussing these options in detail today. Because if I already tell you what options will be considered, that may affect our future arrangements and make the options less effective than they would have been.
I cannot accept this. We've waited for so long. We want the administration to tell us what other options are being considered to resolve this problem with right of abode of children born to mainland parents in Hong Kong. So what's the point of inviting the expert J here if he's not going to tell us anything? Mr. Michael Tin, I have some questions. The CE said last year that the private hospitals should not take on any mainland pregnant women's appointment. And he told the mainland pregnant women that if they wanted to come to Hong Kong in 2013 to deliver babies, he could not promise that those babies will enjoy the right of abode in Hong Kong. What is the legal basis of his remarks? As I understand it, if both parents are Chinese citizens and the baby is born in Hong Kong, the baby has right of abode in Hong Kong. And how many these so-called babies born to mainland parents have there been in Hong Kong? So how many are we talking about that these babies would potentially lose their right of abode? How many of these babies have we had in Hong Kong? I think the Secretary for Security can supplement. From January 2013 to the end of April, altogether 73 such babies were born in Hong Kong. According to our existing law, in particular, in the light of the immigration ordinance amended after the Chong Feng Yun case, these babies do have the right of abode in Hong Kong. As regards the private hospitals policies, and the policies was changed, so there was no promise that the babies delivered in Hong Kong would enjoy the right of abode. I think he was trying to tell the pregnant women that there was no promise. There might be changes. So he was trying to say that I can't promise that there may be changes. So your understanding is that that something might have happened, so that the promise could no longer be kept. Is that your understanding? Well, my understanding is that when the CE said what he said, the government already decided to resort to legal channels to address the issue. But of course, the SAR government respects the rule of law, giving the prevailing law, the prevailing immigration ordinance, which has not been amended, and before another ruling is handed down by the Court of Final Appeal, or before other measures have been taken to tackle this, we'll have to deal with these mainland babies born to mainland parents in Hong Kong in accordance with the basic law. In other words, we cannot deny these babies the right of abode. Did you say 73? From the January to April 2013, we have had 73 babies born in Hong Kong. Secretary for Security? Yes, let me supplement. 73 babies. Were those babies delivered by mainland pregnant women without appointments, and they just gate crash A&E department? You know, from January, starting from January, we have adopted a zero quota policy. So these pregnant women could not get any appointment in Hong Kong. These 73 women came to Hong Kong through various means, and before they are due for baby delivery, they crush A&E department. Mr. Albert Ho, we know that the MPCSC is a political organ. Interpretation of law should be the remit of the judiciary. Every time the MPCSC interprets the basic law, the interpretation is binding on our courts, and sometimes the interpretation would overrule our CFA judgment. So in interpreting the basic law, the MPCSC is exercising some judicial power in Hong Kong, and therefore the independence of the judiciary and the rule of law will be compromised. That's why we have so strong a reservation against seeking interpretation, and that's why the professional bodies are representing the legal professions have such strong views against it. Under Article 158, the MPCSC can exercise the power to interpret the basic law under certain circumstances, and that is before the Court of Final Appeal comes to a final judgment or makes a final judgment. And with respect of issues not within our autonomy, the CFA can seek an interpretation from the MPCSC. In the recent foreign domestic helpers case, we expressed strong views that because you asked for interpretation by the MPCSC in respect of the foreign domestic helpers case, the subject matter is within Article 24, something within our own autonomy, and that is under Article 158, the MPSC should not interpret the basic law in respect of our domestic issues. So that's really regrettable. Of course, the administration has some views towards the Chong Fong Yuen judgment, but no action has been taken to address this. And the procedure is not transparent. There's no consultation, and no consideration has been given to the impact on our rule of law. And you are now concerned that in the long run, the administrative measures would become ineffective. But you haven't got other options, fallback options. Ms. Kwok asked you about the other options, and you are not willing to tell us what options are being considered. So what's the point of our attendance today? If you don't, you're not happy with the CFA judgment, the most proper way forward is to amend the basic law. And there's an article in the basic law for the amendment of the basic law. Is that part of your option? Thank you. I think I should clarify one point. Mr. Ho said that in this case of foreign domestic helpers, we asked the CFA to seek interpretation in respect of some domestic affairs. That's not correct. In the Court of Final Appeal, we raised two issues about seeking interpretation. We are talking about Article 158 and the interpretation of 158. In the CFA's judgment, right from the very outset, is stated very clearly that what we were trying to seek interpretation for. And that is the same as the case of Leung, the same approach, especially in terms of the categorization, whether it's something that the Court of Final Appeal of the SAR can adjudicate, or is something that can fall under Article 158(3), and the judgment, especially in the paragraph 110 and paragraph 111, the CFA states very clearly that our application is considered appropriate, because that's in accordance with Article 158(3) about what should be the subject of interpretation. And the CFA has already stated very clearly that we are not trying to seek interpretation in respect of some domestic issues. I think Mr. Ho should be made aware of that. And second, we are asking our Court of Final Appeal to invoke the Article 158(3), i.e., it's up to the CFA to decide whether in this foreign domestic helpers case is an appropriate case to seek MPCSC's interpretation. This time, the CFA decided that no interpretation should be sought, because the CFA thought that relying on other grounds that they could have handled the particular appeal case in question. It said nothing about whether it would be appropriate to seek interpretation. And also in paragraph 111, the CFA stressed that the proposed approach is plainly the right approach. Of course, we know in the community some people have raised the possibility of amending the basic law. But we are now talking about amending a constitution, a constitutional document. It cannot be done overnight. Among many options, we know that there are people in the community who would like to have this adopted. In our study, we would cover this. Whether it's appropriate or not, I am not in a position to comment now. Thank you, Secretary. Next, we have Mr. Wong Yuk-man. Madam Chair, the administration, well, as SPJ, as a senior government official, you have to obey the Communist Party. Article 158 is very clear about this. And now, when you want to seek interpretation, or when the CFA seeks interpretation, well, it's nonsense. The Communist Party decides everything, and now you want to bypass 158, and you can bypass the second subparagraph, because according to the Constitution, the MPCSC has the right to interpret the basic law. And now I want to talk about Article 158, whether it's the SAR government seeking interpretation by the NPCSC or giving a gentle reminder to the CFA to seek interpretation. It's a violation of Article 158(3) by invoking the Constitution. You say that this is not bound by the bracket 2, bracket 3. Then I would say that you are doing whatever the Communist Party is asking you to do. You can tell the CPG that administratively there's no option. I won't talk about babies born to mainland women in Hong Kong. Other members have been asking you to amend the basic law. Article 158 and other articles. They are just empty provisions. I don't know whether Mr. Yuen understands Article 158. In the mid-80s, when the basic law was being drafted, we attended so many seminars. I wrote a treatise on the basic law after the consultation draft was published.
For all these articles which are most controversial, we talked to the drafting the Basic Law Drafting Committee, and actually Articles 158 is a compromise among all parties. It's China is under the civil law. It's a civil law jurisdiction. It doesn't have any judicial independence, And in the judiciary, they have a secretary from the Communist Party serving in the judiciary. The electrical should be formulating laws, and then the judiciary should be interpreting the law. Now, actually, Article 158 is a compromise of all sides. Now, Article 158 bracket 3 aims to help the judiciary retain this power of seeking interpretation. At the drafting of the basic law, and actually this was a result of the Chinese government at that time, which was relatively more open-minded. Mr. Rimsky-Yuen, Mr. Hu Yaobang was the Secretary General, and Zhao Ziyang was the Premier. And when there was the British side and the Chinese side negotiating on the joint declaration, and hence we got this result of Article 158. Now, you are reverting to a conservative approach, and among the 4 exercises to seek interpretation, only one on the Congo case was sought by the CFA, and one time it was sought by the Tongqihua on the universal suffrage, and the 2 other exercises were initiated by the government itself. Now, I understand that this is a comment from you. Now, you may be given some other time to supplement later on. Next, Ms. Emily Lau, Madam Chair. I believe that the Secretary for Justice understands that if you seek the MPCSC's interpretation to address the problem of children or babies born to mainland mothers, then that's going to arouse a public outcry. There is a strong objection in the community. Well, some people do agree with you, but please take a careful look. Don't try to deal a blow to the rule of law in Hong Kong. Originally, you thought you could hand over your responsibility to the court to resolve the issue for you, but unfortunately, it didn't work that way. And luckily, it didn't work that way. The Secretary is non-committal today on whether to seek interpretation or whether to amend the basic law. Well, you mentioned that that can't be done overnight, the amendment of the basic law. But then if this is a right approach, I think the SARG should have the courage to go and talk to the CPG about amending the basic law. Now, conversely, you should tell the CPG that if interpretation of the basic law is the route that is going to be taken, then this is a price that we can't afford to pay. We don't want you to suddenly go up to the CPG and seek for interpretation of the basic law. That is going to deal a heavy blow to Hong Kong. Secretary, can you be clearer on your approach in the future? Secretary, Madam Chair, and thank you, Ms. Emily Lau, for your question, and perhaps I'll respond to your question as well as Mr. Wong's at one go. Now, on seeking interpretation, the SARG fully understands the community's views on seeking interpretation of the basic law. As what Ms. Emily Lau said, if we arbitrarily resort to that route, then that is going to bring negative impact to the society. I can promise that. Well, the SARG fully understands the public sentiments in this area. As for seeking interpretation, there are 2 models. One is using Article 158 bracket 1 and the other 158 bracket 3. I must emphasize that the SARG knows that if we resort to Article 1581, and that is asking the CE to take the initiative to seek interpretation, then that is going to arouse a lot of controversy in Hong Kong. This we understand very well. And I can assure members that in handling babies born to mainland pregnant women or on other issues, while Ms. Emily Lau might recall that in April 2000, this panel has also discussed the matter, and the administration said at that time that this would be the last resort. Now, up to now, the SARG has been very clear on this point, that we would not resort to interpretation and down that route. So I have emphasized again and again. Now, apart from administrative measures, we are also looking on legal channels within the local legal system. Mr. Tam Yu-chung next. Madam Chair, seeking interpretation of the Basic Law is part of our Constitution. And actually, the MPCSC has the power to interpret the Basic Law, and that is very clearly laid out in Basic Law. And no matter is this CBG or the SARG, we will not easily seek interpretation of the Basic Law from the MPCSC. And every time when it is done, it's just that we don't have any other alternatives. And the results of the interpretation help us in resolving the legal issues we faced. So this is something which is constitutional and legal. Now, on the issue of babies born to mainland pregnant women, this issue has been upsetting us for quite some time. Now, we've been seeing good results through implementing administrative measures, but we can't be sure that the results are here to stay. And perhaps we should consider other alternatives as well. This is something that the SARG must take note of. Now, I have a question for the Security Bureau. I heard reports that some people resort to false marriages to circumvent the law. Indeed, there are such cases. And, well, Secretary, do you think that many people will resort to such kind of tactics? Now, what are the preventive measures that can be taken against such cases? Secretary, please. Since we've implemented the administrative measures clamping down on mainland pregnant women, we expect that mainland women will try to give birth to Hong Kong through false marriages. So when these women come to Hong Kong, we will question them. And the information on hand shows us that we have a dedicated team within the Immigration Department to identify dubious cases, and we will conduct a thorough investigation. Let me cite an example. If a mainland female plans to come to Hong Kong to get married, and then, well, actually, he was married on the mainland, and he suddenly got divorced, and when he was when she is applying for marriage registration in Hong Kong, and she's already pregnant. So this kind of case is very dubious. Well, so we try to look out for signs like these, and if we find that the cases are suspicious, we'll definitely follow up. There is another female who came to Hong Kong and gave birth to a baby, and we traced the records and discovered that when she was conceived, and actually her husband and herself were staying in different places, one in mainland and one in Hong Kong. So if these are the kind of evidence that we found, then we would conduct investigations. Well, so this special team of the Immigration Department has been working hard, and we have successfully taken out prosecutions. And the people concerned have also been put into jail after they have been convicted. So there is a strong message to drive home, and that is anyone who tries to circumvent the law getting into Hong Kong through these kind of illegal channels, they will be subject to penalty in Hong Kong. And if they do this, then that would only do harm to their baby. So if Mr. Tam wants further information and figures from us, we can provide the information after the meeting. Next, Mr. Leung Kwok-hung. Madam Chair, interpretation of the basic law is an issue close to our heart. Now, if the MPCSC is going to interpret Article 158(1), then we are left with no freedom at all. Now, there have been 4 cases of seeking of interpretation of the basic law after the handover. The first, there was one time when Mr. Tong Chi-wah was seeking the interpretation, and that was the way he did it was very scary. Secretary, when you are in a court case, you might seek for interpretation of the basic law. A court case may involve ordinary members of the public.
The council may say this may ask the CFA to seek interpretation, otherwise it may regret later. And if it's in your favor, it's good. Of course, a council behaves like that. But when you are in a litigation, in a court case, you are the other party to the case. If as Secretary for Justice and in a court case, you seek MPCSC interpretation in the middle of the case, it's very inappropriate. It's just like act of government. There are many different types of litigants. They all fight for their own interests. And now, before delivered a final judgment, the Court of Final Appeal may be right in seeking interpretation under Article 158(3). But the government doing this is certainly not recommended. It's not going to be acceptable. You can ask a person to approach the CFA and ask for the same interpretation. That can be done, but that would not look as bad on you. In handling babies born to mainland parents with no Hong Kong ties, it's a domestic issue. We don't need to seek MPCSC interpretation. But of course, there is some nexus involving the CPG, because in seeking interpretation, it must be something that has to do with the CPG's power. But I would say that Hong Kong is well equipped to deal with this issue on ourselves. It's a separate issue. If we enact a piece of legislation and the CPG thinks it's no good, then they can try to seek to have the law changed. That's another matter. But as the head of the DOJ, you should not be concerned about this.
it's always not advisable to seek MPCSC interpretation. We can amend our laws or, in appropriate circumstances, seek interpretation. Thank you. That's just your comment. Maybe I can provide a quick response. I just want to repeat a point. Whether we're talking about Article 158(1) or Article 1583, is part of our constitutional system under the Basic Law. And I hope members can refer to the CFA judgment this time, which has talked about the interpretation at length. That's not something that would affect the rule of law. I hope everyone will respect the one country, two systems principle and also the constitutional order as enshrined in the Basic Law. Mr. Christopher Chung, I want to talk about paragraph 13 of the paper. The Secretary has said that the Department of Justice will actively continue its study and research on other legal options, including those options proposed by the public, legislator, and so on and so forth. With regard to the question raised by Ms. Dennis KWOK, the S4J responded by saying that this is not the right occasion to discuss the matter. So if this is not the right occasion, what occasion is suitable? Secretary, as we've said, at present, there's a body of opinion saying that the administrative measures adopted by the government have proved to be effective. So far, we have not presented other legal options. In the future, when it's considered that we need to pursue other legal measures or legal options, depending on the nature of the options, we may give an account to the public or to this council in advance or after the decision is made. Let me follow up. We have a dozen or so cases each month, and only 100, 200 cases per annum, so there are not many. But as Mr. Tam Yu-chung has said, if they manage to enter Hong Kong through other means, would that be the right time to consider, as the Secretary has put it, other legal options? Would it be the same as the export limitation on baby formula? If you don't want to amend the Basic Law and you don't want to seek MPCSC interpretation and you want to stay within the local legal system, just like the export limitation of baby formula, you just try to insert something into the import and export ordinance. And in this case, maybe you want to insert something in some laws. If you enter through illegal means, you will be in prison for 6 months and fined $500,000. Would that be an option for you? Well, we're not going to do this indiscriminately. For a long time, we have worked in collaboration with Guangdong authorities and the Immigration Department. And I would say that this is not the same case vis-a-vis the export limitation of baby formula, and the two should not be compared. My feeling is that the two are exactly the same. You something across the board, impose an immediate limitation. You stop something at once. On one case, on the one side, you resort to administrative measures. On the other, you insert some provision into an existing ordinance. Any supplement? Not for the time being. Mr. Ronnie Tong. Well, there's something that I must say. After Mr. Rimsky-Yuen has assumed the post of S4J, whenever he talk about babies born to mainland women and seeking interpretation from the MPCSC, I always listen very carefully whether it's a radio news report, and so on and so forth. It seems that he has confused his own role and his status. He seems to regard himself as a private counsel, legal advisor to the CE. And what Mr. C.Y. Leung wants to do is to seek a solution within the legal system. Or maybe he has confused his own status. And that is he wants to do something politically expedient as head of the DOJ. I want to remind Mr. Yun that as for J's status and role is such that the S4J is not just a legal advisor. According to the conventions and our constitutional order, you are supposed here to uphold justice and safeguard rule of law. Aren't you ashamed of yourself? The two representatives for the two legal professional bodies have made this so clear to you today that in respect of interpretation to tackle the right of abode of mainland babies born in Hong Kong to mainland parents, they are saying that this is very inadvisable. This is not the right occasion to rule out interpretation. But you should not try to achieve political aims through interpretation. That's the crux of the matter. You are here towing the official line to tick. You are saying that I'm not going to seek interpretation, but I'm just trying to seek other legal options. I'm very disappointed at you. I have views about Mr. Wong Yan Leung, but he is very firm about this. He said within his term he will not seek interpretation. He would not turn the post of S4J into something like a political tool. Don't you understand? Madam Chair, the Secretary is so evasive in a meeting, saying things that no one can understand. I think the Secretary should reflect upon himself, and next time he comes, he can tell us in no uncertain terms that he would insist on the so-called legal options, and that means something. He can tell us specifically what he would like to do and what ideas, what suggestions have been made to the CE to prevent the undesirable consequences. Well, I've heard Mr. Tong, but I beg to differ that I have some confusion about my role. And as Secretary for Justice, I have the duty to uphold the rule of law and also justice in Hong Kong. When it comes to interpretation, we may have different views. As regards the very serious accusation made by Mr. Tong, I think I find it regrettable. I hold certain views, you may hold certain different views. We have explained ourselves very clearly. I hope Mr. Tong would take a good look at the judgment of the CFA in regard to Article 158, and in this case involving foreign domestic helpers, we are not trying to use interpretation as a kind of political tool. I don't know on what basis Mr. Tong has made such an allegation. Next, we have Mr. Chan Yun Han. Madam Chair, well, I was supposed to be with the development panel, but I want to say something. Well, this problem has been nagging us for a long time. And now the administration has stopped some strong-handed measures, and the situation has improved. For how long, we don't know. We have worries. People in the community are also concerned because if it gets worse, what can we do? At this stage, perhaps we don't do anything more about it. But if it comes back, what is it that you are not going to do anything else? When we went to see Mr. Wang Guangya in March, it was a hot topic. Well, we thought we knew that if interpretation was actually done, maybe we could solve the problem once and for all, but that was not the case. Secretary, well, certainly we are not going to say that we'll do nothing more if the situation changes for the worse. But there is a body of opinion in the community that so far the administrative measures have proved to be effective. And that's why we want to stick to the administrative measures. But as we have stated in the paper, administrative measures may not be able to solve the problem for now and forever. And that's why we are now assessing, we're weighing different options. When the situation changes, we'll take appropriate measures appropriate to the circumstances. I did discuss this with different people, ordinary citizens, and some lawyers. If the situation changes, what are you going to do? If you want to do something about the immigration regime, I'm not for it. I don't want the government to break the law. So what options do you have, Secretary? Can we do something about, can we tamper with the immigration regime? Well, it was reported in the press that certain options might be pursuable, and some people ask me whether we are going to adopt different provisions which are not in line with the CFA judgments. Let me put this clearly. The SAR government is a government that upholds the rule of law. We're not going to do anything that go against our laws.
But what will we do actually? Then we'll have to assess the situation at the time before coming up with any proposals. We can't say anything for sure at the moment. Well, there are still two members who have raised their hands, Mr. Porter and Mr. Chen Kam-nam. I've discussed with members just now because there are fewer deputations than expected coming in for the next item, so I will allow more time for this item here. But I'll draw a line here. Or do you want to raise points or speak a second time? Well, this meeting will last until 7:30 p.m. Mr. Paul Chair and Mr. Chan Kam-nam, and then I'll draw a line. Mr. Paul Chair, Madam Chair, I'm sorry. I am running from one meeting to another. We talked about the order to restrict the export of baby formula. In the next room, we were angry about the government's handling of the matter, but because of the definition of what is powdered formula, and then the government hasn't done anything to make good the definition, so we are very angry. Now, Mr. Ronnie Tong has been making very serious accusations just now. We talked about Article 158 on interpretation. Many members of the community would tell me that now you are a doctor, why would you agree to seek an interpretation from the MPCSC? Now, under Basic Law Article 158, the MPCSC is vested with the power to interpret the Basic Law at any time. Now, although the MPCSC is not a legal entity or doesn't have legal power, it is not like the Privy Council back in the old days. Well, we were very comfortable with the Privy Council in those days. Now, why is it that people are worried about the MPC-SC and not the Privy Council? And we can rest assured that the MPC-SC will not be interpreting the law basic easily, but law is law. Now, if there is this clear stipulation, say that the law will be interpreted by, say, Mr. Ronnie Tong, and Mr. Ronnie Tong is a very trustworthy legal expert, better than the MPC-SC. But we might not be comfortable with him interpreting the law. But then the law is law. If it is stated categorically that this body has the power to interpret the law, then so be it. So I would like to say that whether to seek interpretation of the basic law is more a political rather than a legal issue. And this is not what Mr. Ronnie Tong has said, that the Secretary for Justice should not seek an interpretation of the basic law. Mr. Ronnie Tong has also hurled his criticisms at our former Secretary for Justice, who said that he would not seek interpretation of the basic law during his term. Now, conversely, I thought that that was not reasonable of doing it, because at appropriate times we should seek interpretation, and we should take the crux is whether we have considered all sides of the matter and whether there are better means to resolve the problem. If there is no such better means, then I think we should seek interpretation. I think it's a political rather than legal issue. Now, Madam Chair, I think that the objective circumstances are quite good, and the government can not think about the issue now, but then the government should not rest on its laurel. My question is there a trigger point at which the administration will start considering seeking interpretation of the basic law? Now, perhaps I would ask Mr. Cham Kam Nam to raise his question, and also myself. I have a few points to make before Mr. Yun is to respond. Mr. Chan Kam Lam. Madam Chair, since 2001, the mainland pregnant women problem has brought a lot of headache to the community. In the past few days, the Education Bureau is considering how these type 2 children should be allocated in terms of the geographical locations of their schools, whether they should study in the North District and Taipo, and also there are other problems like housing, welfare, and so on. All these problems are confronting us, and the problems are going to get worse in the future. So to resolve this problem, it warrants our immediate attention. Rather, it is a very pressing problem. We can't wait any longer. Now, because we have the judgment from the Chong Feng Yun case, and that went against the original intent of the basic law. Of course, you understand that we should uphold our legal system. It's best that we refrain from seeking interpretation. But then seeking interpretation is not unacceptable. Now, in the CFA's judgment, it also says that it is an appropriate arrangement. And also, the basic law states clearly that the MPCSC can interpret the basic law when necessary. So we shouldn't view interpretation as an interference on the rule of law or dealing a blow to the rule of law in Hong Kong. The Secretary for Justice should uphold the rule of law and justice, and he should exercise the power conferred upon him to do anything for that aim. He should not be constrained in any way, or he should not be constrained and say that he should not seek interpretation of the basic law. I think rule of law should be upheld in the community, and we shouldn't see interpretation as a monster. The administrative measures that we are implementing are only administrative in nature, and they are not sort of legal measures. So if anyone seeks a judicial review or administrative review of the measures, then that would also create uncertainties. So in this case, I hope the administration can immediately take action, including seeking interpretation. But of course, if the CFA can make amends to its original judgment, then that would be best. If not, then we might have to resort to other legal options to resolve the issue. Administrative measures are not long-term measures and can't eradicate the problem. I have a follow-up question myself in paragraph 5 of the paper, and the issue has triggered public outcry, and there weren't enough hospital beds, school places, and people were infuriated. And at the LegCo, we discussed seeking interpretation of the basic law and implementing administrative measures and so on. Now, in paragraph 5, we are directly elected members. Now, such protests have subsided largely now. But then, in the paper, you said that the people are resorting to different measures to circumvent the law, say by obtaining foreign travel documents and entering Hong Kong from overseas. Now, you talked about 73 cases just now. Secretary for Security, have you made an analysis of how these 73 cases have circumvented the law? Are they entering through illegal means, or traveling by boats, or what? Well, this is something that we don't want to see, traveling by boats. Now, after the babies are born, have the women been repatriated to the mainland, whereas their babies are still staying in Hong Kong? How many cases have been handled by you? Can you have a breakdown or analysis of the figures? Now, if you can't provide the information now, give us the information later. All right, Secretary for Justice and Secretary for Security, please answer us at one go. The ways of circumventing the law. One is when the pregnant mother were still at an early stage of pregnancy. They come into Hong Kong, and then till the very last minute, they gate crash at ANEDs of hospitals. Now, because they are coming in at an early stage of pregnancy, the possibilities of us detecting them are remote. And then there are cases where they are trying to sneak in when there are peak hours at the immigration control points. And then there are other cases where they just try to rush across the border at the last minute. And then some women came in through other means. The immigration officials at the front line are facing challenges of all kinds every day, and they try their very best to deal with various situations. If mainland pregnant women breaking the law and giving birth to Hong Kong, we will act according to the law. Now, babies born in Hong Kong are permanent residents in Hong Kong. And normally, the mothers will take their children back to the mainland with them. And once they've got the documents from Hong Kong, the children are taken back to the mainland. Now, in paragraph 5, you mentioned about they coming from overseas. Now, if there are babies not taken back to the mainland, then there are problems. Now, there aren't many cases, or not one case, when the babies are left behind, because the babies are already granted the permanent resident status, and the mothers usually take their children back to the mainland. Now, if these mainland women are rich, they may travel to overseas countries. Are there such cases? If they travel with foreign travel documents and we found them to be suspicious, we may refuse them entry. All right, Secretary for Justice. I want to respond to Mr. Chair's question. I'm sure you will agree that the right of abode of children born to mainland mothers, this issue is a complicated issue. And because of this, we are assessing the situation on a long-term basis. And I can't really give a definite answer on at what point to take what actions. We won't be able to do that now. But as I said, the DOJ and the Security Bureau and the Immigration Departments are monitoring the situation closely, and if needed, we would take necessary action. As I answered another member's question, we would not think about solutions after the problems have arisen. We do have plans. So all in all, the problem is so sensitive and complicated. It's a political issue. And this is a problem that we have to resolve. And I hope that the electrical members and members of the public can hold an objective and fair attitude and don't get too politicized.
Any supplement from the Law Society? Our position is clear. We are not in favor of the executive taking the initiative to seek MPCSC interpretation as a means to solve the problem with babies born in Hong Kong to mainland parents. I would like to thank the DOJ representatives. We have asked about some statistics and figures. For example, gate crashing cases. Actually, we invited security panel members to our meeting. So we wrap up our discussion on this item. Now let's invite the next group of guests to join us. This is item 4, handling of sexual offences cases. It's CB 4439 1213-01. We have a paper from the administration, and CB 4439 1213-02. Again, another paper from the administration on the procedure adopted by the police. And the next paper is CB 4439 or 478 1213-01, administration's paper on existing measures by prosecution division of DOJ in handling victims in sexual offences cases. And the fourth paper is CB 44679 1213-05, administration's paper on protection of victims or witnesses of sexual offence cases during court proceedings. Today we also have 5 deputations
who are here to offer their views. And we have got a paper from Dr. Monique Zhang, an academic who have provided us with this submission. Let's invite the administration's team and also the deputations to join us now. If the administration team doesn't mind, I would like to invite the deputations to speak first, so that in your speech you'll be able to respond to their concerns. The first deputation to speak is Hong Kong Committee on Children's Rights. Each deputation will be given 5 minutes to speak. So, Mrs. Priscilla Lui, you may start now. Madam Chair, members, government officials, in the preamble to the right of the child, it says that the state parties should allow children to live in an environment of love and accommodation. In the declaration, it says that children are not yet fully developed. Before and after they are born, they need special protection, including protection under the law. In February, the UN met with some NGOs in Hong Kong. A list was subsequently published asking for the administration to explain why no dedicated organization to protect the child's right has been taken on board. And also, some statistics on rape cases should be provided in order how the victims can be protected in prosecution cases. Sexual offense is a serious crime. It affects the family and the community at large. And recently we have witnessed many appalling local and foreign cases. We understand that sexual abuse cases are not isolated cases. We cannot try to understand these cases based on personal experience or personal understanding. Each case must be assessed carefully. Sexual offense is not a foreign problem. We have a serious problem in this regard. According to the SWD, from January to March 2013, among the child abuse cases, some 40% are related to sexual abuse. And there are many unreported cases. Unreported cases are numerous. Compared with, I would say those successfully prosecuted are the minority, and the victim, the children, suffered a lot. Sometimes there are difficulties in prosecution because of lack of physical injury, or the victims cannot get sufficient protection. So without proper protection, we cannot handle such cases properly. All the parties concerned must have guidelines to follow. We must have a proper definition of sexual abuse. The present guidelines are very unclear. We have a wealth of cases. I would like the administration to review the cases in the past 10 years and also try to glean some special characteristics of these cases through the recorded evidence, and also to consider better ways to provide training and come up with a better definition of sexual offense. The guidelines do not contain anything about the roles played by the prosecution, judges, and other parties. We would like to involve judicial officers more extensively, like other professionals. The victims are unable to speak for themselves. Their legal representatives, therefore, assume an important role. would like the administration to provide suitable legal representation for each and every victim, and this should be in the guidelines. And the sentencing guideline, and also the system to check sexual offense records must be reviewed. We have witnessed some appalling cases recently. It seems that the current guidelines and rules and regulations are inadequate. Every party involved must assume its role. And we have seen the publication of the review of mortality cases, but I think the review should cover the sexual offenses. This September, we'll see Hong Kong SAR submitting a report on the implementation of a convention as part of China. The world will see how much we have done to create this environment of love and care for our children, what we have been doing to do our utmost to safeguard the well-being of our children. I hope our officials would approach the hearing with a clear conscience. Next, we have Dr. Jessica Ho from Against Child Abuse. We want to make 6 points with regard to this item. We believe we should comprehensively review relevant laws and make amendments. Under the existing law, a man having sexual intercourse with a girl under 16 commits an offense. But if both parties are under 16, and even if the girl took the initiative, and if the boy has reached the age of 10, he commits an offense. So the law protects the girl, but there's no protection for the boy. During the age from 10 to 13, the children are in a critical developmental stage. They may not be able to tell the right from the wrong. They may not have the ability to understand the entire criminal justice system. They need protection and guidance, not prosecution. We would like to urge the administration to raise the criminality responsibility age to 14. Second, we want more attention to pay to the emotional needs of children and the timely provision of treatment and counseling. The paper refers to the expedited procedure in handling sexual offenses, which involve vulnerable parties such as children. The trial would always take time, and in the investigation and judicial process, we should be mindful about the psychological needs of the children. We should not delay the provision of treatment or counseling just because the court case is still pending. Thirdly, we need to have training that is interdisciplinary in nature. Sexual offense cases rely on evidence more than prima facie evidence. That professional training is required, and so that they have the necessary skills to make the assessment. And social workers, police officers, and healthcare workers are getting one-off training most of the time, and other professionals such as lawyers and judges don't get much training in this. Especially when we talk about cases of child abuse, sexual offense, or human trafficking, we need expertise so that the professionals can handle the cases properly. And also on the verification of a sexual offense, sexual offense records. This is a voluntary system. It has been implemented for over a year now. Some 40,000 cases have been received. There's only one such center, and the waiting time can be more than 1 month. We hope more resources and manpower can be provided so that more officers can be set up to expedite the processing of such an application, and the application fee should be waived. And more importantly, there should be a statutory mechanism. At present, we can only check the record of potential or prospective employees, but there are existing employees that we need to check as well, especially if we are talking about tuition teachers engaged by the parents, or we are talking about carers of elderly and children. They should also be covered. At present, the Correctional Services Department offer clinical, psychological counseling to the sexual offenders if they have a tendency to commit the same offense again. Such service is even needed to a greater extent. If it's assessed, if this service provided by CSD is considered effective, then in the sentencing, the counseling should be part of the consideration so as to reduce recidivism. And the paper talks about different approaches to deal with sexual offenses which have been around for years. It's time to have reviewed so that we can learn from experience and to improve on existing procedures, measures, and laws. And we should also try to track and trace the reasons of such offenses. And I would like to stress that many cases remain hidden. There should be more publicity to encourage people to come forward to report these cases. Next, we have Ms. Linda Wong from Association Concerning Sexual Violence Against Women. Whether we're talking about adult children, the court should offer us the same protection to them as vulnerable witnesses. There should be comprehensive measures to make sure that witnesses will not be frightened, and the evidence obtained will be of high quality and is good to secure conviction. We have 4 suggestions. With regard to CAP 154, we should learn from the UK so that the protection which should be accorded to the witness and the sexual experience of the witness with a third party should not be the subject of questioning. At present, questions can be raised about the witness' sexual or victim's sexual experience with a third party, and we think this should not be allowed. And also, the witness should have the right to testify through the live televised arrangements. And also, Section 79B should be extended because vulnerable witnesses should be allowed to testify through a television live feed. At present, there are no sufficient guidelines provided to the court to assess whether a witness is one suffered with terror. Under the prosecution policy and guidelines, paragraph 22.5, the measures are comprehensive, but they are not legally binding. We would like to incorporate those measures in paragraph 22.5 in the prosecution policies and practice into the law. And also, screening should be provided for all witnesses involved in such cases. At present, this is done on a discretionary basis by the judges, and different judges adopt different practices. When a witness wants to be provided with screams, he will only know on the day of the trial. And if one is not provided, the victim doesn't really know where the fault lies.
I want to talk about the difficulties of applying for screen provision. It is very difficult now because the judges are afraid that screen will become a ground for appeal by the defendant. So we hope that the screen provision can be provided to the victims. the screen provision is rejected on the ground that it will affect the right of the defendant. But we have to see what rights will be affected. Well, the right to fair trial. While association thinks that the screen actually will help enhance the quality of the witness's testimony and that it's conducive to fair trial. And victims have to suffer again when appearing on court, and when they recollect or talked about the incident again, then they sometimes will withdraw, and that would affect the trial. And if there is a screen, then the quality of testimony will be enhanced. Also, in the defendant's counsel cross-examining the victim or the witness, the counsel can actually observe what the victim or how the victim is doing. Now, the screen provision can be very flexible. We can take reference from overseas jurisdictions. The screen protects the screen can cover the public and the defendant, and then the defendant counsel can still carry out an effective cross-examination. Well, there are many such practices of screen provision in common law areas or jurisdictions, and that they should be sharing the same common law as Hong Kong. In New South Wales, the sexual victims can apply for screen, but then the judge can reject that, but giving reasons. But in Victoria Province, there is also this provision. And in also UK or England, that this right is also granted. Next is Ms. Tiffany Ng from Ring Lily. Well, actually, a lot of the victims told us that before they appear in court, they are very worried and afraid, and I hope that they can testify behind the screen. Now, according to the experience of our association, it is very difficult for the victims to apply for screen provision, and many of the applications have been rejected. And in many cases, when the court doesn't accede to such a demand, the victim refuses to appear in court, and then the charges are withdrawn. Now, in some cases, the court asked us to provide a psychological report, but in other cases, no such reports are required. So we are mystified what the practice is and what criteria are being adopted. And some victims also told us that the judge said that the court is a very safe place. You don't have to be afraid. And so on that ground, the screen application is rejected. I think that kind of answer is lack of sensitivity. The victims are not afraid that the court is too dangerous. They are just afraid to go through the experience again under the court. No, even if they are testifying with their back facing the public, then even if they have to share again in the court her experience, and it's just like having her assault experience again. So that is going to affect her. So we hope that the administration we hope the administration appreciate the pressure faced by victims and that they can be protected by a screen. Now, in the course of the trial, the prosecution official should protect the victims' personal data so that they would not be disclosed unnecessarily. Now, in many cases, actually, the defense prosecutors are disclosing the victims' telephone numbers and addresses and so on, and the judge doesn't put that to a stop. In one case, the victim's telephone number was disclosed, and then she received later on a reporter calling up her asking for an interview. She was under threat and under serious harassment. There is legislation that unless with the permission of the judge, the counsel should not question the victims on her sexual experience outside the incident. But in most cases, the victims was cross-examined on her sexual experience outside the sexual assault incident, and the victim was forced to answer, and then she had her privacy rights infringed and suffered. So how can we ensure that the relevant legislation can be effectively implemented to protect victims' privacy? Now, the police also submitted a paper that it will provide a one-stop service to victims and to expedite the investigation process. But in our experience, it seems that the police's investigation procedure doesn't differ much from the past, and the victim had to share her experience, and then shared with the CID her experience, and she would be taken to other places to for examination in the police station with the forensic pathologist and so on. And she was made to wait in all these procedures. Well, sometimes it was waiting for a long time, and in some cases the procedures take up to 22 hours. So you can imagine how the victim suffers because of such waiting time, and she has to repeat over and over again her very unhappy experience. And when she is very tired, a victim will give substandard testimony. So I would like to understand how the police provides its one-stop service and how it can help the victims. Now, in most cases, after the procedures have been completed, helping services are provided to the victims, and the victim said that she wants all sorts of helps during the investigation process. So would the police make a review of your procedures, and so that the services can be referred to the victims as soon as a case is received? Next, Ms. Yu Lai-fan, Vice Chairman of Iowa Limited. Thank you, Madam Chair. Well, we have 2 points to make on the guidelines. The government departments are dealing with the cases. Have they explained in detail to the victims the rights of the victims when they are dealing with a case? If a victim has questions, or she said that she thinks she is being unfairly dealt with, and she is embarrassed by the police, are there any ways that she can make a complaint? And second, there is a mechanism to protect privacy of the victims. The police has also instituted training for police officers on that regard. Now, has the administration made any effort to let the public understand what their rights are, and have the administration taken any efforts to implement, to monitor that such policies are implemented effectively? Thank you, Ms. Yu. Yes, I would now like to ask the government and the police to respond. First, Mrs. Leung, Principal Assistant Secretary for Security. Yes, well, we'll first have the administration responding, and then Mr. Bruce. Perhaps I would respond briefly on the police's work. Well, perhaps you should speak to the mic, Mrs. Ng. I would respond on the police's work, and for matters relating to the courts and the judiciary, then perhaps other colleagues can tackle. Now, for the police's handling of sexual offences, the police has handled all sexual offence cases with care and sensitivity, and the objective is to prevent further abuse and also prosecute the offenders. In investigating sexual violence cases, the police has in place a number of measures to protect the victims, having regard to their privacy and also their psychological conditions. We have listed out those in our paper, and if we have time, then the police's chief superintendent can supplement. I want to stress that the police officers dealing with such cases are specially trained on how to, in particular, deal with children's sex offense cases. Some friends also mentioned just now that they are worried about sex offenses relating to children. The police also attaches importance to these kinds of cases. Now, whenever there are these cases coming to us, the police will work with the child psychologist to deal with the cases, and there is a dedicated team to work on that as well. About the sexual conviction record check mechanism that was implemented since December 2011 by the police based on recommendations of the LRC. Now it's been implemented for over a year, and we're now conducting a review. And actually, the security panel has decided that an agenda item will be included in the meeting on the 4th of June. Mr. Matthew Hemmings, please.
Security Bureau has said, in terms of the interviews, if a case of sexual violence or sexual offences comes to our attention, we will interview the victim in private, and we will do so as soon as possible. And that will be done by a police officer of the same sex as the victim, and the victim may have a friend or a relative present. If it is a child or a mentally incapacitated person, then we will usually do we will video record the interviews in one of our vulnerable witness interview suites. In terms of training, our officers are receiving training at all levels in respect of sexual offences. For example, recruit inspectors and constables at the foundation or basic training level will learn the various concepts in relation to investigating sexual offences. This may concern heterosexual couples or same-sex couples. Also, domestic sexual violence incidents. They'll also receive tips on the psychological profiles of the victims and also conflict management. Later on, the criminal investigators will receive further, more in-depth training at the standard criminal investigation course and the advanced criminal investigation course. We have a lot of procedures laid down in both force procedures manuals and the criminal investigation manuals in respect of how to deal with sexual violence or sexual offences, and these are reviewed periodically to make sure that any improvements that are necessary will be laid down, so that we keep pace with new legal developments or emerging crime trends, etc.
Okay, 多謝Mr. Hemmings.
Thank you, Mr. Hemmings. May I also invite Mr. Winnie Tang to supplement? I would like to supplement that for adult sexual offense victim reports a case. We offer around-the-clock service. For example, if psychological counseling is required, we are assisted by the NGO in providing around-the-clock service. We also try to reduce the trauma faced by the victim. Will try to repeatedly ask the same questions. As long as we know that this is a case of sexual offense, trained personnel will be involved. We stress the importance of sensitivity, professional sensitivity to the to interview the victim. This is an important part of our training. Next, let me have Mr. Wesley Wong, Deputy Director of Public Prosecution for the DOJ. I would like to say something about the practical side, the court proceedings. In the pre-trial stage, we will go for some pre-trial verification before the proper court proceedings start. If the prosecution learns from the law enforcement agency concerned that the victim or the witness has some special needs, we can raise the matter with the court so as to avoid the court being told of the issue the first time when the court hearing starts. And this can also will of course be helpful in avoiding delays. In relation to sexual offenses, the DOJ has a special system to advise us on the provision of legal advice and also in fast-tracking the hearing. We have been in cooperation with the police and the court on this. And of course, we will also get experienced lawyers, whether within the DOJ or from those in private practice, to prosecute for us if the case is serious. Mention has been made that during the court proceedings, personal particulars of the victim were disclosed, and actually this happened, and it was pointed out for attention by some Court of Appeal justice, and we have reminded our prosecutors to be careful. For example, some information must be kept in writing, and if reference has to be made to personal particulars, the particulars should not be submitted orally as far as possible in the presence of public gallery. Next, we have Mr. Fong Man Chung from the SWT. Some deputations would like us to extend the ambit of the review committee on mortalities involving children to cover the sexual cases. Well, that committee has 5 terms of reference, and that is to review the handling of cases involving children mortality, to learn from the experience in order to improve the services, and also to review the implementation of recommendations, and to monitor the trend so as to come up with preventive measures, and to promote interdisciplinary collaboration to prevent children mortality cases. Well, different stakeholders may have different definition about serious injury cases. There's no consensus on how to go about such a review. And if we talk about living persons, then confidentiality must be handled carefully. And if there's a criminal case pending, conducting a review may delay the court case. If we are talking about domestic violence case or cases involving serious injury sustained by children, the services most needed in the first instance would be for the family, instead of conducting a review. So we don't see a case for extending this review system to the children's sustaining serious injury. In today's press conference, we were talking about cases recorded in 2008. All these cases have been subject to coroner's hearings. We don't really want to repeat the victim's audio after some time. We have reservation about this suggestion. Next, we have Mr. from the judiciary. So what can the judiciary do to protect these vulnerable witnesses or victims? Well, we set out the measures in the paper. There are administrative measures that we can adopt, and I won't talk about the details. From the perspective of the judiciary, protecting the witness when necessary is an important matter, but we have to be mindful that whatever we do, we have to ensure that the trial is conducted fairly. The parties all have their rights that we need to uphold. And there are different protection measures that we can adopt. I won't repeat the details, which you can find in the paper. Next, we would like to have Mr. Andrew Bruce from the Bar Association, especially in respect of the protection, the criminality, responsibility, age of 10, and the protection of boys, and UK experience.
Thank you. Thank you very much for inviting me. The bottom line remains the right to a fair trial and the right to properly defend yourself if you're charged with a serious matter. That has to be balanced, everybody recognises, against the rights of young children and the more general right to liberty and security of person, which everybody enjoys. And I think it's fair to say the Bar Association supports anything that recognises that balance, but it must be a recognition of that balance. Previous sexual experience is already restricted under our laws at the moment. Could we do better? Yes, no doubt. We had the most modern provisions 20 years ago. We have stuck with what we've got at the moment. I think we could do a whole lot better, and experience in the United Kingdom and various states of Australia would demonstrate that. But a recent judgment of the English Court of Appeal said all of those restrictions are fine, but they must not ultimately impede the right to a fair trial, which is considered a non-negotiable right. But that said, we could do better. Disclosure of data, of course, there is that terrible case that we're all familiar with. But I can tell you routinely from long experience, the papers we get from the police and the prosecution routinely redact personal details such as phone numbers and addresses and the, identity cards and other matters. And any matter that is disclosed to counsel representing an accused comes on a very, very limited basis. We are allowed to use it for the trial and the trial only, and that does not include releasing it to the press, and the accused himself or herself is restricted by that rule as well. And it's a rule that is one that we ought to remember. The idea of making a decision about screens in advance rather than on the first day of trial seems to me such an obvious idea that I wonder why we haven't really moved forward on that. Every major trial in Hong Kong has a pre-trial review There's a whole lot of reasons for that, but one of them could be, and I think probably should be, a deliberate question: do we need screens or other special protection for alleged victims of crime? Now, my own experience is any time a well thought out, proper application for that is made to the courts, and usually if it's done in advance, so everybody's got a chance to think about these things rather than doing it on the first day of trial and so on, which is not a clever idea. Judges, in my experience, have been pretty sympathetic to that. Again, there's that balance I talked about, and where to strike the balance, that's what we have judges for, and there won't be a perfect consistency, I've got to tell you, but it's not bad. As far as cross-examination, particularly of children, I've become aware recently of some guidelines published by the English and Welsh High Court, which restrict the right of counsel for the accused to ask questions, particularly of children. And they're guidelines at the moment, and they've only had a couple of years of experience, so I can't tell you at the moment whether they're working, but they certainly cut down the traditional modes of cross-examination to quite some extent. But let me tell you this, anybody who knows anything about a good cross-examination knows that if you cross-examine children in the same way we would cross-examine an adult, you're likely to be very ineffective. You're not going to get your points across. All the style that we use for, dare I say, grown-ups doesn't work with children. You're not communicating. And so these guidelines, as far as I've read and understood them, seem to be just plain common sense, and it may be something that my distinguished colleague, Mr. Wong, might want to take up for the Department of Justice in due course. As far as how a trial in relation to sexual offences is conducted, there is a body of law which has existed for a long time, which is well understood. We take into account precedents from all over the common law world, and we mix them against our fundamental rights, which are enshrined in the basic law. Could we do better? Short answer, yes, but we don't do real bad.
Okay, thanks, Mr. Andrew. 我哋就係請委員發言。
First, I would like members to ask questions. 5. Dr. Helena Wong, Ms. Elizabeth Kwok, Ms. Emily Lau, Dr. N. Chong, and Mr. Paul Chair, and Ms. Sid Ho. 6 altogether, and although Mr. Dennis KWOK. So everyone present wants to raise a question. 3 minutes each, please. I have the discretion to extend the meeting time by 15 minutes. Dr. Helena Wong. Thank you, Madam Chair. The Secretary for Security was criticized for his remarks about warning girls drinking too much to avoid being raped. Well, the Secretary has not withdrawn or retracted his remarks, and this kind of thinking is prevalent among the police force because the victims are not taking extra care to protect themselves, and they are raped. Now, I have 2 questions for the police. I welcome the police's paper saying that you will provide one-stop service for victims of sexual offences. And you also mentioned that you would provide training on dealing with domestic violence. And then, if you have come across these cases, you would be asking the same-sex police officer trained to deal with the sex violence victims. These are very good measures. You mentioned about the one-stop service model, and some deputations said that actually the one-stop service takes a long time, and then the victim has to retell the story time and again to different people. And in her particular case, all the procedures took 22 hours. The process was really slow, and it inflicted a lot of pain on the victims. Can you speed up the procedures? That's number one. And number two, you've talked about the training on sexual violence. How many frontline police officers or those in the middle grade and the senior grades have undergone such training? Is it the case that in any police station, whenever one comes forward reporting on sex violence case, there is definitely going to be at least one police officer who has been trained to deal with these cases? So I just want to know how many people, for officers, or have undergone such training. Now, my next question is for the DOJ. The victims are allowed to testify behind screens, and some deputations said that it hinges on the judge's ruling on whether screen provision is allowed, and there are no guidelines in this respect. So my question is, the DOJ, would you consider amending the legislation to regularize the screen provision for sex victims appearing on court, unless the sex victims deliberately says that she doesn't need a screen? I don't know how many court judges have undergone training so that they are sensitive to the victim's feelings. All right, can you be brief in your reply? A screen provision. Mrs. Ng, perhaps? One question for the police. Dr. Helena Wong. Well, 3 minutes have passed. Perhaps they can reply overall later on. The second member, Ms. Elizabeth Kwok. Thank you, Madam Chair. I would like to thank the deputations and individuals for coming in to give us so many valuable opinions. There are 3 papers issued by the administration. On the surface, it seems that they are doing well in protecting the victims so that they do not have to go through the ordeal again in their investigation of their cases. But I wonder whether the measures are really implemented effectively. It seems that for these organizations, deputations here today serving the victims, it seems that the measures are not effective. Now, for the police says that it has a one-stop service, and then there is organization asking what is one-stop service, and the police said that the victim would not have to repeat her testimony. Now, my question for the deputations: in your experience, when you accompany your victims to report to the police, is it in your experience that one-stop service is provided? How many times does the victim have to give the statements? Ms. Ng. Thank you, Ms. Kwok, for your question. The victims, how many times do the statements have to be taken from them? The uniformed force, and then the CID, and then that she may be questioned in another district, and then the serious crimes, and then the forensic pathologist, and then in the hospital. Well, many times. So I hope that the police can explain what do they mean by one-stop service. The police force in Hong Kong is really professional, but then in the training provided the police officers, Are they trained on the fact that victims should not be asked on their sex experience apart from their sexual assault? Well, in one case, the victim was questioned many times about her sex experience with her ex-boyfriend. How is it related to her sex offense case? So, police, one-stop service. Yes, who is going to tackle that? Mr. Hemming.
Yeah. The intention of the one-stop service...
Can you speak to the microphone, please? Yeah.
The intention of the one-stop service is that we're trying to reduce the trauma and stress for the victims, and the idea is that the interview and any forensic examination, and if necessary, any further medical attention will take place at the same location. So that might be in a public hospital, for example. But there are practicalities involved, and although that is the intention, and we try and do that, sometimes it's not possible. Maybe the interview will have to take place later.
Okay. 跟住係劉慧卿議員。
Next, Ms. Emily Lau. Well, thank you, deputations, for coming here to give us your views. I hope the administration has heard your views. I have to ask this question. In the last meeting, I raised the same point about the screen provision. Well, those who have a say in whether to provide a screen, can you answer us? So what is the actual arrangement? Is it the case, as what some friends here mentioned, is it's very rare that screens are provided? Can the DFJ tell us, or the judiciary, rather, tell us what is happening? Well, Ms. Lau, in the past, the screen was not provided by the judiciary. But recently, for every level of the court, we have screens. But as to whether screens are needed in the various cases, it depends on the individual case. The DFJ colleague has said that the earlier the request is made, the better it will be. I can't give a general answer now. Under what circumstances will screens be used? But the ultimate test is based on the principles of fair trial and judicial independence. So the judges will consider the cases on a case-by-case approach. Mr. Wong, the DFJ. Now, if we know through the police that the witness of such requests, we will gather information from the police for our consideration. And if appropriate, we will raise our request to the court. We would present the legal and the factual grounds, and then we will present them to the defendant's side. And if they object, they have to give good justifications, and it will be up to the judge to decide ultimately whether screens are going to be provided. Well, is it the case that many of the requests have been declined? No, not necessarily. It depends on the individual case. The relationship between the victim and the defendant, that will also be factored in. Well, is it the case that you reject most of the cases? Now, wow, you had what they say. Every court level has a screen provision. Well, do you want to respond now? Yes, Ms. Wong. Now, you said in the statement of prosecution policy and practices, it is said that a screen provision can be provided and also victims can testify through live TV link. But it seems that the victims or the witness doesn't have a right to apply. So that's why we ended up with the situation we are in now. Next, Mr. Paul Chair. Several questions. First, Mr. Bruce is very right. He has a wealth of experience in these kind of cases, and he's also a scholar. Why can't a checklist not feasible or in the pre-trial review? Can we not come up with a checklist? I think that's relatively simple to achieve. Now, also about making statements for a number of times. Can we model after the ICAC? And that is the statement can be taken through video recording, and so that different districts and different departments don't have to take statements again. I don't think there is any technical difficulty here. Thirdly, about the screens, I agree that why can't they be provided? Also, fourthly, about witness in fear. For children or mentally incapacitated persons, for them, can they be can they be covered under the lifelink testimony without proving that they are witness in fear? Administration checklist. Mr. Wong, about pre-trial review. Well, this is being implemented now. If there is a need now, the prosecutions. Well, I'm not saying about prosecutions. I'm talking about the checklist, and you would take a look at the checklist, and you will know that there is a need for the provision of screen without the prosecution having to go through the case again. Now, before the trial, we would together with the police to see if the victim has such a request. Yes, Mr. Porcher has been chasing you after the checklist. Well, you are an experienced prosecutor. I'm just talking a thing as simple as a checklist. And then, well, you can go through the checklist every time, and then you have to look at the case in detail. Don't have to look at the case. Then we have to seek from the police the necessary information. Well, checklist, he hasn't answered my question on the checklist. Security Bureau, any supplement?
Oh, Mr. Wong, I want to refer to another question. It is a vulnerable witness. If we want to do this for adult witnesses, we need to amend the law. Mr. Ho, well, I can't ask meaningful questions in 3 minutes. If we ask for legislative amendments, it would take 10 or more years, and it would stop at the LLC. We want to have a screen provider to protect the witness in giving testimony. And as the government paper says, it's just there to try to avoid eye contact between the victim and the accused. It said that the DOJ will have to gather information first and to ask the defendant whether it's against this. So when will the defense agree? If without a screen, the witness is a witness in fear, can the reverse be provided? Unless it's considered unsuitable, a screen should be provided. Can you provide this as of right? Well, the practice is for the judge to approve this, so it's up to the prosecution to apply. Well, so this is the practice, and you can exercise this question. Can we legislate for the provision of screen? Because this is one of the major concerns. Can we do this? I think members are very interested in getting an answer from you. If in the law we reverse the basis, things would be very different. Actually, Mr. Wong, this is not really a direct answer. Because, well, they are repeating themselves. Can you adopt an open mind and provide
screen for the victim. Some members are saying that this is administratively provided, and if we want to do it in our law, which law are we talking about? I think the prosecution and the police can be more proactive to ascertain whether there are certain basis for raising this request in the court. The ultimate decision is made by the court. As things stand, unless an order to this effect is issued by the court, the provision will not be made. I think we are going to make a request in the name of the panel after the discussion. Mr. Dennis KWOK. Again, I want to ask a question about the provision of screen. Well, if you have listened carefully to the questions and the views expressed by the deputations, they're asking that the prosecution be more proactive and ask for a screen earlier. I'm told that the witness is only told about the provision of screen on the first day of the trial. So Mr. Porter proposes that we can have a checklist, and also we can ask the prosecution to be more proactive. DOJ is responsible for prosecution. You are also responsible for ensuring the procedural justice in relation to witness testimony, and we want to avoid a witness refraining from testifying because of the lack of a screen or because of fear. So it's not just a question about whether we need to amend the law before this can be done. The DOJ, as prosecution, must be more proactive and consider the provision of screen. Instead of asking the witness to be kept in the dark and the witness has to guess whether it will be provided. You can try to ascertain this through your interview. As long as you are more proactive, I think this can be solved. Mr. Wong, can you be more proactive? Can you consider using a checklist in relation to the provision of screen? We are willing to be more proactive. Second round, Ms. Elizabeth Kwok and Ms. Sid Holt, and I would do a summing up. Ms. Kwok, I will continue with my questions about screens. I would rather do away with the application requirement. Why do you need an application? You need police to provide you with the information. So the witness has to make a request to the police, and the police will have to provide the information to the prosecutor. Why can't the prosecutor just apply for one? And when we talk about witnesses, when children are witnesses, they are regarded as vulnerable, but not when women are victims. Maybe in the eye of the police and the DOJ, women victims are not regarded as vulnerable. And therefore no special treatment should be given. So please understand that this should be given as of right. It should always be provided to the women victims. Well, sometimes the woman doesn't look vulnerable, and they may become the doubtful witnesses. So I want to get some figures, some statistics. How many rape cases have been tried in our courts in the past few years, and how many cases involve the request to provide screens, and how many were rejected? Well, I don't have any figures with me. I will try to dig out some from our records. All right. There's another one who wants to speak in the second round. It's Mr. Paul Chair. I want to give more time to the administration to say why we cannot model the statement taking after the ICAC's practice, and that is a video recorder, instead of asking police officers to do it again and again. You know, some police officers write very slowly, and some would ask more questions than others. So perhaps we can get an experienced officer, and it's recorded, and officers can refer to the recorded evidence more than one time. Mr. Hemmings?
At the moment, we do video recorded interviews for children, those under the age of 17, and also mentally incapacitated persons. For the other witnesses, we will interview them. But I think, going back to an earlier question, we don't try and prolong the process. I mean, we're aware that the victims have been traumatised, and we don't wish to add to that. So we will try and reduce the number of statements that we take. Obviously, if we can get all details in the first statement, that is ideal. But sometimes, depending on the nature of the case, you have to do some follow-up inquiries.
But the crux of the question really is, why can't you extend to the women victims as well, apart from the children?
I think I'm...
Mr. Hemmings 仲有冇？嗱，我哋仲有啊，葛珮帆議員呢，就係我諗佢唔問第三次呢，佢就好。
All right. 1 minute for you, Ms. Kwok, for the third round, and then I will ask for an overall response. We need to wrap up now. Actually, the police hasn't really responded to our questions concerning one-stop service. I hope they would consider our views carefully and come up with an improved response on how we can make improvements and to offer more protection to victims. Well, there's some follow-up required here, and some deputations have raised the question of young offenders. The age is now lower to 10, and some has proposed 14. I think Mr. Bruce has got some views on this. So this is the first point. Some follow-up is required. We'd like to have your side of the argument. And also some members would like to have expedited one-stop service, and whether each and every sexual offense case is handled by experienced officers. And then the third issue is screen. I think it's unanimous here. Members would like the DOJ to consider making this as something as of right, unless it's deemed unnecessary. Because under the common law, it's up to the court. Our suggestion is the view of the panel that in respect of the provision of screen, you can do it administratively, or maybe there must be a clear guidelines in the law. We hope that this is no longer discretionary. This is the second time we discussed the subject. I hope we can get a satisfactory answer and proper follow-up action. And some members have asked for figures. For example, in the past 5 years, how many cases of application for the provision of screen were rejected? We would like to see some outcome arising from the discussion. So can you respond to some of the issues here and now, Mr. Singh? Regarding the issues raised by the chairperson and members regarding training of police officers. I'll ask the police to respond. As for the age of criminality, this council enacted the amendments to raise the age from 7 to 10 based on the study of the Law Reform Commission. So it's now 10. It's based on the LRC's recommendations. We believe it's appropriate. Some people are concerned about those under 14 who may be prosecuted. Well, under the common law, there's a presumption that may be able to protect those under 14 because the prosecution must prove the mens rea and the burden of proof is high. We believe the current safeguard is adequate, and we have no plan to change the age of criminality. As for training, I would defer to the police.
One of the members asked earlier how many of our officers are trained. I'm sorry, I cannot give precise numbers, but I'll have to talk in general. Basically, all recruit constables and inspectors learn basic concepts during the foundation training. But it is, cases are investigated by CID officers, and all CID officers attend the standard criminal investigation course and will learn techniques as regards how to investigate sexual violence offences.
How about expediting the one-stop service? Can we get some response? It's also a matter of concern to members.
Well, as I said earlier, we try and execute these procedures as quickly as we can, and also all our procedures in relation to investigation and follow-up procedures in relation to sexual violence offence cases, they're laid down in established procedures which we review on a regular basis. So we're not resting on our laurels here. If there's ways we can improve, then we will certainly do that.
I think our views have been made very clear, and I believe the administration is aware of what this panel would like to get done, and it's very much a consensus from the panel. And please provide the statistics requested. I think it's time to adjourn the meeting. Thank you for staying with us all the way to 7:45. Let's hope that we can get some positive response from the administration in due course. Thank you all for coming. Meeting's adjourned. Thank you.